Okay, let's get started. We have a lot of ground to cover, so I want to go ahead and jump in. Welcome to Arnold and Porter's webinar on carbon capture and sequestration, state initiatives, state primacy, and Class 6 permitting. My name is Brian Israel. I'm the chair of the Environmental Practice Group at Arnold and Porter and co-chair of our ESG working group. Very happy to welcome you today. Before we get started, I'd like to go over just a couple of housekeeping notes, which is, first of all, if you'd like to submit a question, you can submit it to the Q&A icon, which is located on the bottom of your screen. We've already received a number of questions when folks were registering, so thank you very much, and we'll try our best to get to all of the questions. If we're unable to get to every question, we will take note of your question and get back to you after the webinar so that your question will be answered. We also have, as part of this webinar, an ebook which contains the slides that we'll be using, today's presentation slides, as well as speaker bios and some additional supporting materials. So that will all go out following the webinar. And if you're interested in obtaining CLE credit for this presentation, the instructions for how to do that will also be included in our follow-up email. So I'm going to quickly, in the interest of time, introduce our panelists today, and then we'll get right to it. First is Romany Webb. Romany is an associate research scholar at the Columbia Law School, and she is deputy director of the Sabin Center for Climate Change Law. Her research focuses on energy and negative emissions technologies, including how the legal and policy tools that can be used to minimize climate impacts of energy development. Prior to joining the Sabin Center, Romany worked at the University of California, Berkeley Energy and Climate Institute. Next, we have Sarah Gray. Sarah is a partner in the Environmental Practice Group in our Denver office. She counsels clients on regulatory, policy, and compliance matters related to climate change. And she's a leading strategic advisor on CCS and other energy transition opportunities. Before rejoining the firm, she served as a regulatory counsel for a large biofuels company and its trade association. Next is Ethan Shankman, a partner also in our environmental group and based in Washington, D.C. Before joining the firm, Ethan served as the Deputy General Counsel at the US EPA, and prior to that, Ethan was the Deputy Assistant Attorney General at DOJ's Environment and Natural Resources Division. Ethan is nationally recognized for his work with climate change policy and regulation, representing clients in rulemakings and litigation concerning biofuels, renewable fuel standards, Clean Power Plan, etc. Next, we're very happy to have Sarah Glover, also from our Denver office and from our corporate and finance group at Arnold and Porter. Sarah advises energy companies on transactional matters and has, over recent years, a particular focus in areas relating to energy transition, including carbon capture and sequestration. We'll be able to bring that perspective to today's discussion. And last but not least is Sam Pickrell, an associate in our environmental practice group based in Washington. Sam represents clients in energy transition industries, including carbon capture, conventional and advanced biofuels, sustainable aviation fuels, and clean hydrogen. So welcome to all of our panelists. I'd like to get started with Sarah Gray, if that's okay with you, Sarah. And if you could set the stage. We know that the Biden administration is very focused on the promise of carbon capture and sequestration to meet net zero ambitions, as well as Congress and international bodies also, all of them of whom are calling for a dramatic expansion of CCS to help address climate change and meet net zero objectives. Notwithstanding that, a few projects are up and running. So I'm wondering if you could address both the promise, but also the impediments to actually seeing carbon capture projects implemented.
Sure. Thanks, Brian. And thanks for having us all here today. Sam, could you go to the next slide, please? I think this slide demonstrates that we have an overall kind of very strong growing pipeline for CCUS projects. And interestingly, if you mapped onto this chart, where state legislative activity is, you would see kind of a flurry around 2009, 2010, and a flurry today, which is consistent with where we're seeing a lot of activity around project development. There are a number of projects that are in the kind of early and just announced stage, but a really large growing number that are in advanced development and under construction. So what's driving all of this interest? And we'll touch on the state legislative piece and the many developments in that area later in the discussion. But Sam, next slide. So part of this is companies have a variety of climate goals that they're hoping to accomplish in part using CCS, consistent with the IPCC, the administration, and many other bodies that have identified CCS as a key technology needed to get to net zero, particularly for hard to decarbonize sectors. So there are a variety of new financial incentives or enhanced financial incentives that are also available for these projects that we are supporting our clients in exploring opportunities. The most obvious one is obviously the enhancements under 45Q in the last couple years, where the benefit for point source capture was enhanced to $85 a metric ton, and then there are significant direct air capture tax credits available as well. At the state level, there are sometimes grant funding opportunities that we're helping clients think about, as well as credit generation through low carbon fuel standard and other programs. So where you're willing to go through the additional steps of understanding and incorporating frameworks such as the California CCS protocol into your project, there are significant opportunities there as well. In addition to in the commercial carbon credit space, through various bodies that certify and verify projects for eligibility to demonstrate, to generate credits in those markets. So next slide, please. There's additional significant financing funding that's available through DOE as part of the infrastructure law. There are a couple opportunities that are available now that DOE is requesting conceptual papers related to how you want your project to be structured, both at the pilot scale and the commercial scale. So we're helping clients think through those sorts of opportunities too. So this kind of taking all of these together, we see that there's a huge amount of interest from potential operators and companies that have emissions that they would like in the near term to be able to be sequestered, in addition to thinking through other opportunities to reduce those emissions. Next slide. So one of the, at the federal level, you could think of it as an impediment, but it's really just kind of necessary to operate, is permitting through EPA's under the Safe Drinking Water Act. So many projects will need to go through the Class 6 permitting process. Some projects will be able to go through a Class 2 permitting process that is administered by many states already, or may soon, or in the Class 6 process, as we'll get to later in the presentation, has a couple states that are in charge of it through the primacy process, but not a significant number of states yet. So the permitting process, if you think of it as an impediment, it's really just that these are extremely technologically complex projects. And in some ways, the science of understanding where a plume will go, and so that once the CO2 is injected, and understanding where the plume will go is fairly advanced, but working with the agency in various regions to try to demonstrate that you have a clear sense of that, and that there won't be any risks for for drinking water sources, is a significant portion of this very heavy technical application that at the regional level. For example, Region 6 has developed what it calls crosswalks, these various guidance documents that will take you through what the permitting process looks like. There are a whole variety of checklists that parties need to be able to understand and engage with on the technical side to prove out their projects. But in addition to all of these technical basics about kind of what's the geology of the well, what's your testing and monitoring plan, what are you going to do post injection to make sure that the CO2 is stable and isn't moving elsewhere. there's an overlay which includes an environmental justice assessment that, for example, Region 6 is requiring parties to submit as part of the application process. So it's not just having strong technical foundation for submitting these permits and having them proceed through the process successfully through the regions or a state body that's taken over. It's also on the EJ side as well. And I think Ethan will spend a bit more time talking about the primacy overlay and how states are approaching environmental justice as relevant to CCS projects. Next slide, please. So there are currently dozens of projects in the queue, many for regions 5, 6, and 9, but for others as well. There are really only one project that has active Class 6 permits, and that's for the ADM ethanol facility in Decatur, Illinois. That permit took many years to obtain, so parties are concerned that the process will be similarly slow. And what we've heard from the regions is that they're estimating about a 2-year timeframe for projects, but that's where you have, all of your technical information pulled together. EPA agrees that you've completed the initial steps of preparing the information, and you can respond quickly to questions they ask. So when we talk to the regions, we sometimes hear one of the key reasons it's slowed down is because applicants can't get back quickly with additional questions that EPA asks. So it's a process where it's not just in the hands of the agency, but in the hands of the project proponents as well as to how quickly they can move through the various permitting gates. Next slide, please. And before I hand it over, I just wanted to note kind of one, if you think of it, if it's perhaps an impediment, but it's just a reality of permitting these projects, you have a state overlay in many, if not all instances, where you may need to be dealing with a state body who has its own rules and regulations around permitting test wells and other activity relevant to this space. So in my home state of Colorado, the Colorado Oil and Gas Conservation Commission has considered itself to have authority over drilling for test wells in the CCS space, even though that body's authority is primarily over oil and gas development. So it's currently kind of applying its rules to the CCS space, but one of the first steps requires a variance because the rules are structured so that you're pursuing an oil and gas development plan. And in this context, that's just not relevant. So these are some of the there's the opportunity, certainly at the state level as well as at the federal level, for ironing out some of the kinks in these processes to make it a bit more streamlined. And I'll stop there, Brian.
Super. Thanks so much, Sarah. You really, point to the tension between the objectives of the administration and some of the permitting and other requirements. I have to ask a follow-up question. Maybe Ethan, who we turn to for all insight on EPA climate policy and capabilities, really. Ethan, do you think EPA is ready for this? For the permitting onslaught? Would permitting reform be helpful? What do you think is the inside view over at EPA?
Yeah, Brian, thanks. I think it's really an open question. This administration hasn't issued any Class 6 permits. The last Class 6 permit that was issued was back in 2014. So there's been something like 6 permits for 2 projects that have been issued in the history of the program, and they've taken between 26 to 40 months to process. So I think there's a lot of concern out there among project developers about the delay in getting approval. 10 months ago, there were only 14 projects in the queue for permits at EPA. There's now 42. So I think it's something we're going to be following very closely over the next couple of years. One sign of hope is that, or on a positive note, is that Congress provided some significant funding for EPA specifically directed to building out capacity to administer the permitting program, $5 million per year over the next 4 or 5 years. So hopefully EPA will put that to good use.
Super. Okay, before we move on to something a little more technical, Ramani, as a subject matter expert from the Sabin Center for Climate Change Law, and just once again, we're so happy, Ramani, that you were able to join us. What is your view as far as the primary impediments or obstacles to to really taking CCS to scale?
Yeah, I think there are some real challenges. And I just want to emphasize like the extent of the increase we're talking about here. Last November, the White House released a report on innovations needed to meet 2050 climate goals. And that report concluded that in order to achieve net zero emissions by 2050, which is what the US has pledged to do, we need to capture and either utilize or store somewhere between 400 million and 1.3 billion metric tons of carbon dioxide. That's a huge increase in about 25 years. We're really building a whole new industry in less than 3 decades. It's a really daunting undertaking. There are, I think, some real challenges around permitting new storage facilities. But if you take a step back, storage is just one piece of the puzzle here. And one particular impediment that I see to scaling in particular is a lack of carbon dioxide transportation infrastructure, and in particular pipeline infrastructure. We have very limited carbon dioxide pipelines in this country, about 5,000 miles currently. And the estimates are that if we want to achieve net zero emissions by 2050 and scale up CCS to do that, we need another 65,000 miles of carbon dioxide pipelines. To develop all that, it's about $1.7 billion in new capital investment. And even if you put the financing to one side, the complexities, legal and otherwise, of developing that pipeline infrastructure is really a challenge. Those pipelines are going to need, in many cases, state and local approvals, which are likely to be very difficult to get. We're seeing a lot of public opposition and local opposition to carbon dioxide pipeline development. And so I think if we're thinking about scaling up and building this new industry, looking at it on a holistic basis, that for me is a real concern.
Super. A lot to think about. I wonder if either of you have a view on permitting reform as a part of the solution, but that may be a topic for a different webinar. But yeah, Ethan.
No, I'll just say one thing about the permitting reform proposals that are being considered by Congress and by the administration. They're not so much directed at the Class 6 Safe Drinking Water Act permitting process, but on the other types of permits that are going to be necessary for carbon capture infrastructure to be built out. So things like NEPA, Endangered Species Act, Clean Water Act, permitting for pipelines that Romany mentioned. So yes, I think there's a lot to pay attention to in the permitting reform space if you're interested in carbon capture.
Okay. All right, so let's try to drill down, if you will, to some more specific issues and related to CCS. And one of the hot topics, I think a lot of people know, is the issue of primacy. Sarah alluded to that issue earlier. And we know that many states, Louisiana, Texas, have applied for to assume responsibility for Class 6 permitting or what's called primacy. But here too, we're seeing some delays. So I guess, Ethan, if you could address what's going on and first of all, explain what primacy means and also why we're seeing this delay.
Yeah, thanks, Brian. So the Safe Drinking Water Act is a statute based on cooperative federalism, just like many of our environmental statutes are, where EPA establishes some baseline standards, but the states have the opportunity to really implement the statute and the program on the ground in the first instance, like under the Clean Water Act and the Clean Air Act. There are multiple types of underground injection control programs and permits under the Safe Drinking Water Act. 31 states and 3 territories have approval to administer other types of permitting programs under the Safe Drinking Water Act, what's called primacy, but so far only 2 have received approval to administer the Class 6 permitting for CO2 injection. And I think, going back to the question about permitting and is EPA prepared, I think one of the answers to that question just has to be more responsibility has to be delegated to the states, and the states have to assume more primary responsibility for permitting, just like they do under other environmental laws. And we're seeing a lot of activity in that area. If you go to the next slide, Sam, we have something that Sam's going to talk about a little later in the webinar. We have together with the Sabin Center, created a state-by-state tracker of state legislative and regulatory developments relating to CCS. And that's the web link. The web link is also in your invitation. And Sam, if you could go to the next slide, please. One of the things we're tracking is which states are applying for primacy. And then there's information you can get on each state and the status of their applications if you click on the individual states. So North Dakota and Wyoming in dark blue, they have primacy. Louisiana has applied for primacy. Its application is complete. Actually, it was determined complete back in the fall of 2021. So there's been quite a delay in that process as well, which is concerning to many. Texas, West Virginia, and Arizona are in the pre-application phase. And we just got news today, or yesterday, that Pennsylvania has announced its intention to apply for primacy as well. If you could go to the next slide, Sam. So I think it's critical to touch on the issue of environmental justice and carbon capture. There is a lot of activity, a lot of things that are being put out by EPA relevant to environmental justice and carbon capture, whether it's the EJ Screen tool, which is a tool that EPA puts out there for both states, regulators, and project developers to determine, to identify communities with potential environmental justice concerns where they're thinking about projects. And then there's legal resources out there. EPA OGC has put out opinions confirming the authority under the Safe Drinking Water Act to include environmental justice considerations as part of the permitting. And then there's just a ton of money that's being made available for environmental justice programs by states or environmental justice communities, or in some instances, potentially project proponents. And some of that can be used towards CCS. Next slide, Sam. So one of the things that EPA, in the context of reviewing and approving state applications to assume primacy for permitting, EPA has recently issued several announcements indicating that the extent to which the states are incorporating environmental justice principles into their programs is going to be critical in the review and approval process. So just in December of 2022, EPA issued an announcement encouraging states to incorporate public participation processes that are designed to be tailored to particular community concerns, to use tools like EJ Screen to consider environmental justice impacts on communities, to explain how they're going to have adequate enforcement to protect communities and address those concerns, and then also to incorporate potentially mitigation measures to actually mitigate some of the environmental exposures that communities have experienced over time as part of new carbon capture projects. Most recently, in January of this year, as EPA was opening applications for funding for states to help them apply for primacy to assume responsibility for permitting, EPA took it one step further and said, as a condition of receiving funding, states now must demonstrate how environmental justice and equity considerations will be incorporated. The Louisiana application did, I think, with some foresight, include a number of requirements relating to environmental justice, including requiring project proponents to conduct environmental justice reviews. Texas left things a little bit more open in their application, saying that there wasn't enough guidance. I'm sure that this is something that Texas and EPA are discussing, as we speak, as EPA is reviewing its application. The last point I'll make is, although these announcements are in the context of what EPA is expecting to see in state applications for primacy, I think this is really an important insight into what EPA is expecting to see in individual projects. So I think it makes a lot of sense for project proponents to be thinking about these environmental justice issues early, and to have a plan for community engagement and to think about how they're going to address community concerns as part of their permit application process, taking into account the issues that EPA has identified in these recent announcements.
Thanks, Ethan. You mentioned Texas, and I know, Sam, you're doing a lot of work following what's happening at the state level, and you'll talk a little bit more about the state tracker. And it does seem that Texas is trying to be a leader in this industry. And I know that primacy is one element of that. What else is happening, Sam, in Texas that's in terms of initiatives related to CCS?
Yes, Brian. So Texas has potential to be a significant state for CCUS development. It's the highest emitting state by a fairly wide margin. It has decades of expertise in geologic industries, including the injection of carbon dioxide in the context of Class 2 oil and gas wells. And it has suitable geology both onshore and offshore. So it's not necessarily surprising that Texas has been a first mover in developing the CCUS legal framework as well. Back in 2009, in the first wave of state CCUS legislation that we're seeing across the country, Texas came out with an initial framework that assigned jurisdiction to the Railroad Commission, established an industry-wide trust fund, some permitting frameworks, as well as a unique legal framework for offshore CCUS. Fast forward to today, and as Ethan mentioned, Texas is again at the forefront by being the sixth and most recent state to be entering the primacy application process. But this is also appearing to be part of a larger group of activities from Texas. Just last week, new legislation was filed, which would greatly expand and build upon their initial framework. And this legislation includes many of the major elements of CCUS legislation that we're following with our tracker. And I'll go into more detail of what those are later in the webinar. But the Texas bill includes clarification over pore space ownership, mechanism to integrate interests in pore space ownership to aggregate enough area to operate a commercial scale facility, framework for eventually transferring ownership and responsibility of facilities to the state after CO2 injections have ceased and the closure process has been completed, an expansion of the existing trust fund mechanisms, and several other areas. So it's certainly legislation that we'll be following closely, and will be interesting to see how everything shakes out down in Austin.
Thanks, Sam. I just have one other question on Class 6. Sarah Gray, I know you've worked with a lot of clients in the development stage of CCS projects. Just a threshold question, do companies want to see states have assumed primacy? And what other thoughts do you have on how companies can improve their chances for getting their Class 6 permit?
Sure. Yeah, it's a good question. I mean, many companies do see primacy through under the Class 6 process help with the states as a benefit in terms of being able to move quickly. And a couple companies in particular in North Dakota have had, that experience has borne out where they have been able to have permits issued on a more quick basis, particularly as compared to the initial Class 6 permits that were issued for ADM that took many years to get through. But I think the ultimate thing that most companies want is clarity as to how to navigate these processes. And so to the extent that there's confusion between whether they'll need to proceed under a state process or through regional permitting, that can pose some challenges. So for states that are moving towards primacy, having clear communications with stakeholders around when that transition may occur. And so they know to whom, who their audience is for submitting the permits and working closely with the agency. We certainly wouldn't want a process where parties, particularly, in Texas, are losing time on important projects because of the transition, if and when that occurs from the region to states. And more general in terms of successfully navigating this process, having extremely clear plans, thorough technical information, thinking strategically about where challenges may be with the permit, both from the technical side and with, for example, environmental justice concepts, and working with the communities in which you're in on, benefits and what the benefits are of the project, and how to communicate about what the project will mean for people in the area. All of these permits have a public engagement component. So that will be really critical for stakeholders in successfully navigating these processes in an efficient way.
Super. Thanks so much. That's really helpful. Maybe Sarah Glover, I know you've dealt with a lot of projects on state land. What's besides the permitting issue, what can you say about leasing on state lands?
Sure. So from a leasing standpoint, we're seeing activity where one would expect the Rockies, the Midwest, and the Gulf Coast. The forms of leases and/or easements are still evolving in the various jurisdictions as practitioners are drafting to provide for this somewhat new business model within existing property regimes. As for states specifically on the Gulf Coast, the state of Louisiana was the front runner, issuing its Form CCS operating agreement first. Operating agreement is Louisiana minerals speak for lease, for those that don't know that. The Mineral Board manages the leasing of state lands for CCS in Louisiana, and to date has entered into 7 CCS leases. In Texas, the General Lands Office grants CCS leases for the permanent school fund lands. And while private leasing is very busy in Texas, the GLO is taking a more measured approach and has issued only 1 lease to date, which was an offshore lease, which we'll talk about later on in this presentation.
Super. Well, actually, that's a great segue, because I did want to turn to offshore in particular and expand our focus a little bit. So this is for Ramani, because I know you've thought a lot about this. There's of course a growing interest in what you were saying earlier about the scale, probably a necessity to explore the potential for carbon sequestration, both in state and federal waters. So can you provide a little bit of a state of the play, if you will, for what's happening offshore and what are some of the unique challenges in developing offshore CCS?
Yeah, great. Well, I would say offshore CCS is generating a lot of buzz, particularly in places like Texas, which we've already heard a bit about. These sort of coastal areas where there are a lot of industrial facilities and other large emitters in close proximity to the coast. And so the idea is that, we can capture the carbon dioxide that those facilities produce, transport it relatively short distances offshore, reducing the length of that pipeline transport that we need, and then inject it into subseabed geologic formations. So rock formations beneath the seabed. Sam, if we go to the first slide. There's thought to be quite significant carbon storage potential offshore in areas sort of close to the US coast. A recent study by the International Energy Agency estimated that the theoretical maximum carbon storage capacity in the United States is just over 800 gigatons, and about 35% of that is located offshore, really around all of the coasts. There are thought to be a number of advantages to operating offshore. A lot of people have argued that because offshore storage necessarily occurs sort of away from populated, built-up areas, we might see less public opposition to CCS offshore, which has been somewhat of a problem onshore. We might see it might be easier to secure social license for offshore projects. The data doesn't really bear that out. And so, Sam, if you go to the next slide, a number of studies have shown that Americans are really concerned about the health of the ocean. They're really concerned about the impact that human activities are having on the ocean, and they want to see sort of appropriate restrictions on activities that could further damage the ocean. So this graphic is from a 2020 survey that was done that found that the majority of Americans think that the ocean is being harmed by human activities. And 95% of the people that were surveyed supported the establishment of more marine protected areas to limit or prevent human activities in parts of the ocean. This particular study didn't look specifically at sort of public attitudes towards offshore carbon storage, but other studies that have shown that offshore storage is generally viewed less favorably than other climate interventions, including onshore storage. So, I think we could very well see a degree of sort of public concern and some public opposition to offshore storage projects. But having said that, there are still reasons to look offshore. There is, as I said, large storage capacity, and it may, at least in some cases, be sort of relatively easier to obtain rights to use offshore formations for carbon storage. So Sam, if you go to the next slide. Unlike for onshore projects where you may have to deal with multiple landowners and pore space owners, offshore you're generally only dealing with one owner, and generally in at least in nearshore areas, that's the coastal state. So there's a federal statute called the Submerged Lands Act that defines the boundaries of each coastal state as extending 3 nautical miles from the coast, except in the Gulf of Mexico, where the boundaries of Texas and Florida extend 9 nautical miles from the coast. The coastal states have primary jurisdiction over waters within their boundaries, and with some limited exceptions, they sort of control the submerged lands under that water. The federal government has relinquished all of its rights and title to the submerged lands within state waters. The federal government does retain some regulatory authority, and I'll talk about that in a minute, but and in some areas, local governments and Native American tribes have certain rights and authorities within state waters. But generally speaking, it's the coastal state that controls that sort of nearshore submerged land and gets to decide if it can be used for things like carbon storage. So far, Texas has been really the leader in sort of moving forward with offshore carbon storage, though other states are sort of actively looking at leasing offshore land for carbon storage. So in Texas, and I think Sarah, maybe we'll talk more about this, but back in April 2021, the Texas General Land Office issued a request for proposals for lease of offshore land for carbon storage. Following a sort of bidding process in September 2021, the Texas GLO announced that it would award a lease for the so-called Bayou, thank you, Sam, Bayou CCS project that was to be, at the time, jointly developed by 2 companies, Talos Energy and Carbonvert. Chevron has since joined and actually taken over that project. The lease was executed in March last year, covers about 40,000 acres of submerged land near to Port Arthur in Texas. So we have this state issued lease, and we could see similar leases issued in other areas. Before you can actually inject carbon dioxide into the seabed, there's some additional hoops to jump through, including if you're operating in state waters, the need for a Class 6 well permit. That Class 6 permitting regime applies both onshore and offshore in state waters. It does not apply in federal waters, though. And so I'll just say a few words about the situation in federal waters, which is somewhat different. So Sam, last slide. So the federal government controls the submerged lands extending beyond state waters, typically out to 200 nautical miles from shore, sometimes a little bit further. BOEM, the Bureau of Ocean Energy Management within the Department of the Interior, is authorized to issue leases on the outer continental shelf, this submerged land underlying federal waters, under a federal statute called the Outer Continental Shelf Lands Act. Now, traditionally, BOEM's leasing authority was limited to leasing land for mineral and energy development. So it's long had authority to issue leases for offshore oil and gas development, for example. In 2005, the Outer Continental Shelf Lands Act was amended to allow BOEM to issue leases for offshore renewable energy development, so wind development particularly. And in 2021, with the enactment of the Infrastructure Investment and Jobs Act, also known as the Bipartisan Infrastructure Law, the Outer Continental Shelf Lands Act was amended again specifically to allow BOEM to issue leases for the injection of carbon dioxide into subseabed geologic formations for the purpose of long-term carbon sequestration. The IIJA directed BOEM to adopt regulations to implement this new carbon sequestration leasing program within 1 year. So those regs were meant to be issued by November last year. That deadline was missed. BOEM has since said that it is working with its sister agency, BSEE, which is responsible for sort of the safety of offshore operations on the Outer Continental Shelf. They are working together to develop the regulations. They have said it's a priority, but it's still a little unclear when the regulations will be released. One other important thing that the IIJA did was it exempt carbon storage on the Outer Continental Shelf from regulation by EPA. Carbon storage projects on the Outer Continental Shelf can go ahead with this lease without having to go through an EPA permitting process. I'll leave it there.
Thanks, Ramani. Since we have Sarah Glover with us, and Sarah was instrumental in negotiating the Texas GLO deal that you referred to, Ramani, maybe Sarah, you could give us a little bit of, without revealing any privileged information, just some lessons learned and perspective having negotiated that lease.
Sure. So again, we were involved through our client, Carbon Verge, who was a member of the JV. It was a great exercise with the General Lands Office, who I had negotiated several traditional oil and gas leases but it was everyone's kind of first rodeo on a CCS offshore lease. So it was a really exciting exercise. I'll just add, Romney did a great job covering the project, but just last week, Bayou Bend, with Chevron now involved in the JV, announced they're going to add another 100,000 acres adjacent onshore to be part of the storage hub of Bayou Bend. And that's kind of sort of the trend, how projects are going. It's, at least in the Texas piece, is sort of an onshore piece with an offshore lease as well. So it's interesting how, all of this is coming together kind of quickly, actually. Louisiana in September also issued its first 2 offshore state water Gulf of Mexico leases, both to Venture Global. One was on the east side of the state in Plaquemines Parish, and the other one's on the west side of the state in Cameron Parish. Something interesting to note in these 2 new Louisiana offshore forms, the State Mineral Board had revised that standard form we saw executed 5 other times to include drill through rights. So i.e. the state's reserving the right to develop deeper depths below the storage facility. And that was already in the GLO concept, which is interesting. Last week, the GLO issued 2 separate requests for proposals for more leasing offshore Texas, specifically in the Galveston Bay area and offshore Corpus Christi, opening up 2 new areas for Gulf of Mexico CCS development in Texas, and bids are due June 12th. So a lot to watch there.
Super. Thanks so much. I have to say there's just Sam, I have to put you on the spot here. There's so much going on, at the state level from a legislative and policy perspective. I just wish there was some way we could follow all of these developments. I'm wondering if you would have any suggestions.
Sure, Brian. So as several of the speakers today have mentioned, there's been a flurry of recent activity at the state level. So to help stay up to date with that, we partnered with the Sabin Center at Columbia Law School to develop the CCUS State Legislative Tracker, which is a online interactive web tool hosted on Columbia's carbon dioxide removal law webpage. And there's the address up here and also in the materials for this webinar. And so in developing this tracker, we looked across the various state legislation and along with reports and secondary sources to pull out what some of the main elements that are seen commonly across states in their CCUS legislative frameworks. And so I'll walk through each of those now that we're covering in the tracker. So first is pore space ownership. So pore space is the gaps or voids in mineral formations or within geologic formations. And that is where carbon dioxide is stored once it's injected underground. So a CCUS operator that wishes to store carbon dioxide will need to first obtain access to that pore space to obtain those rights. If there's a piece of land that is owned by a single owner that owns both the surface of the land and the minerals underneath the land, it's pretty straightforward in most cases that that owner would also own the pore space. But if you have land where the surface estate has been severed by the minerals, severed from the mineral estate and owned by a separate entity, it can be less clear whether the surface owner owns the pore space rights or the mineral owner owns the pore space rights. And for a potential CCUS operator, it then becomes unclear who they would need to negotiate with to obtain those rights. So we see in the light green color here, states that have decided to address that question by clarifying in statute who owns pore space rights. And each of these states that we've seen so far has assigned those rights to the surface estate owner. The next element we looked at is common mechanisms to combine ownership interests. So in order to develop a CCUS facility at a commercial scale, it may be necessary to obtain pore space rights from many different owners. And if the CCUS operator is required to reach negotiated agreement with every single one of those owners, it may incentivize some owners to hold out for higher payments or hold out to block the project. So we're seeing some states address this by allowing a CCUS operator with the consent of a majority or supermajority of the owners in a particular area to apply to the state for an order that would combine all pore space ownership interests in that area over the objection of some minority of non-consenting owners. And so a lot of the concepts for this are borrowed from conventional oil and gas law. And we'll see the terms vary considerably between integration or pooling or unionization. And some states even use eminent domain. So Louisiana and Alabama authorize eminent domain for CCUS projects. If you click on a particular state in the tracker, it'll pull up more detail. And so here for Indiana, it'll explain some of the requirements that a CCUS operator would need to demonstrate to the state before these this combination can occur. So you see there's a 70% minimum requirement that the pore space owners within the project area will have consented. There's also requirements that the operator have a valid Class 6 permit, have made good faith efforts to negotiate with all the owners, and that the non-consenting owners will be equitably compensated. And to go for even further detail, to go directly to the text of the statute, we have links included here that will take you there. The next main element we looked at are frameworks for long-term state stewardship. So when carbon dioxide once it's stored underground, it needs to remain there in perpetuity. And this extends beyond the expected lifespan of any given company. So some states have addressed that by establishing frameworks by which a facility, after injections have ceased and the facility has been closed, for ownership of that facility, along with responsibility and sometimes liability associated with that facility, to be transferred to the state. And now these provisions are sometimes more controversial than the previous two provisions that I discussed. And you'll see there's slightly fewer states that have enacted them than pore space or integration provisions, but still a good amount of the states that are legislating in this area are including this type of provision. A lot of the discussion related to these mechanisms revolves around how to ensure that CCUS operators are still adequately incentivized to operate with due care. And so states approach this in a variety of different ways. Often there will be various technical requirements that an operator will have to demonstrate to the state, showing stability of the site before any transfer can occur. States also sometimes will put in waiting periods of several years or even decades, so that if there is anything wrong with the site, it would be more likely to arise before transfer occurs. And states may also include safeguard provisions that would void or nullify any transfer if the operator has committed fraud or other misconduct. And so again, here in the tracker, if you click on a particular state, it'll give you a brief summary of what some of these requirements are, along with a link to the statute itself. And also if the user has interest in, say, one particular state, so let's say they're particularly interested in Utah, this little menu over here allows you to quickly go between the different Utah provisions. So mindful of time, I'll go fairly quickly through the last three elements we're looking at. Trust funds are mechanisms that states often put in place to collect fees from operators, and often those funds are tied to the stewardship programs that I was just talking about, but also the funds can help offset other administrative and regulatory costs, such as costs of permitting or inspections. Primacy is something we're closely monitoring, and Ethan has discussed what that means in more detail earlier in the presentation. And then the last item, whether CCUS is included in state climate action plans. So this is not legislative in and of itself. These are policy documents that a state can put out to demonstrate its plan for meeting its climate goals. But we've included it here as a potential indicator of states that may enact CCUS legislation in the near future. If they're committing to the technology in their public policy documents, they may be more likely to follow that up with an actual legislative framework. And so the last thing that I'll say about the tracker here is that we plan to be continuously updating it and improving it. So we have our email address down here that you can send comments and suggestions to. So if there's particular proposed legislation you think we should be keeping our eye on, or if you have an idea for an additional layer to add on to the map, this email is open to anyone to help continue to improve this resource.
Thanks so much, Sam. This is great. I was a little disappointed you didn't highlight California, but my great state where there is the capacity to sequester carbon at current emission rates for over 1,000 years. And of course, California has committed to reduce by 85% its emissions by 2045. So the capacity to store carbon will extend significantly beyond that time period. But fortunately, in your materials, there is an article that goes into a little bit more depth about the some of the recent developments, including legislation in California related to CCS. I wanted to ask one of the questions from the audience, I think, touches a little bit on some of the points that Ramani and Ethan had been making earlier in the environmental justice context, but also just a bigger picture question as we wrap up this webinar, which is there a concern that as we scale up sequestration that will reduce or obviate the urgency of reducing emissions and recognizing that this is a concern that has been articulated by some in the NGO community. So maybe I open it up to the panelists generally, if anyone is interested in addressing that question.
Yeah, I'm happy to weigh in on that, Bren, and maybe others have thoughts as well. In academic circles, we talk a lot about this idea of mitigation deterrence. The concern that things like CCS and in particular, atmospheric carbon dioxide removal, where we're actually drawing carbon dioxide out of the atmosphere, things like that will discourage efforts to decarbonize and move away from the fossil fuels that are producing these emissions we're now trying to do something with. When you talk to climate scientists and when you look at things like the Intergovernmental Panel on Climate Change reports that talk about the need for CCS and carbon dioxide removal, they really talk about that as a sort of last resort to deal with those really hard to decarbonize sectors where there are not ways to swap out those emitting sources. I think that in the context of domestic politics and legal frameworks, we've seen and heard sort of conflicting messages around what role CCS and carbon dioxide removal should play, including from the administration, though I think a lot of the recent documents do reflect this idea that it's really about the hard to decarbonize sectors. And there's more, we need more clarity around sort of how these techniques will plug into broader climate policy frameworks. I will just say two other quick things. One is that we are having this very debate here in New York City, where I am, because we have a local law that's aimed at reducing emissions from buildings. And the thinking when we adopted that local law was that we would reduce emissions by moving away from oil and gas for heating. One building in the city has recently installed a small carbon capture system that captures its emissions in order to avoid making that transition. And so there's an active debate in the city right now about whether that should be allowed under our local law. And I think we're starting to see debates and discussions around how we can craft sort of legal and policy frameworks that enable these activities that we do need to move forward with, but make sure they're used in a way that sort of furthers our overarching climate and environmental justice and other goals.
Hey, Brian, if I could just
Sure.
jump in with one comment, just thinking about this issue from the perspective of an actual project that needs a Class 6 permit, and the extent to which environmental justice considerations will be incorporated into the permit process. I just think this is a question that, where I think everyone needs more guidance from EPA and from state regulators as to the scope of the environmental justice analysis that has to be conducted, and whether it needs to include some consideration of upstream indirect effects, at the source of the emissions, as opposed to at the site of sequestration. But I'll just say that I think it's going to be really, really difficult and probably unwieldy and inefficient if a project proponent at the site of sequestration has to consider upstream indirect effects, when I think we're moving towards a system, if CCS is going to be developed at scale, where there's going to be networks of pipelines transporting CO2 from many, many different sources, and to have to sort of trace back where particular CO2 is sourced from, and then do an analysis of upstream effects, I think will wind up being both cumbersome, not that helpful or fruitful, and could result in a lot of delay for project proponents.
Yeah, that's a great point. Thank you, Ethan. So we're bumping up toward the end of our hour. Ramani, I wanted to give you the last word as our special guest and co-sponsor of the state tracker that Sam described, to give you the last word.
Yeah, thanks, Brian. I would just encourage everyone to make use of the state tracker. It's really an amazing resource, and I think Sam and the team have done an amazing job of compiling all the other information. And I will just put in one quick plug for some of the other resources that we have at the Sabin Center. We have a very extensive climate litigation database that we co-manage and co-maintain with Arnold and Porter. And then we have a variety of other online databases and trackers, including a new one that we just launched last week that's tracking implementation of the Inflation Reduction Act. So we hope everybody checks it out and finds it useful.
Super. Thanks so
Brian.
much. And thank you, everybody. Thank you, all of our panelists. Thank you for all of our participants. This concludes the program. And as I mentioned earlier, we'll send a follow-up email. We'll include a link to an evaluation form. If you could fill out, we'd really appreciate it, as well as information about obtaining CLE credit and the slides and some additional materials. I know there were a couple of questions we didn't get to. We have those recorded, and we'll contact you offline. And if you have any questions that you weren't able to ask, please feel free, of course, to contact us directly. And thank you again for participating in today's webinar. Have a great day.